All rise. The International Criminal Court is now in session, hosting the English Moot Court Competition 2014. Please be seated.
First, I would like to greet the teams of the Counsel for the Prosecution, Defence Counsel, and Counsel for the Government of Southaros. I welcome as well the courtroom staff, the security officers who diligently assist us all in our work. I would also like to greet those in the public gallery who have taken the trouble and opportunity to come. The participants in the ICC moot competition attending this hearing and those outside the court who are joining us via the internet in this moot court competition. Now I turn to the issue of photography and video recording. The Chamber has authorised video recording and the taking of photographs for 2 minutes and no longer. So, Court Usher, may I ask you to usher the photographers into the courtroom? Thank you. Good morning. You have 2 minutes to take your pictures and no more. Thank you. Thank you. I would now turn to the court usher and ask that the case is called, please. Could you call the case, please? Thank you.
Thank you, Your Honor. We are sitting in the case of the prosecutor versus Theon Redberg in the situation in Northeros, ICC Moot Court Competition, 2014 English version.
On behalf of the Chamber, I would now ask the parties and participants in this hearing to introduce themselves, please, beginning with the prosecution. But before you start prosecution, counsel, I would like to ask all the parties and participants to speak slowly and to pause before responding to any question, in order to allow all the participants to follow the proceedings closely. Now, could I ask you, prosecution counsel, please to present yourself and the members of your team.
Mr. President, distinguished members of the court, my name is Ayana Yakubovic and I'm the counsel for the prosecution. Sitting next to me is my co-counsel, Ms. Ofil Sharon.
Thank you. I now turn to defense counsel. Could I ask counsel to present the members of your team, please?
Distinguished Appeals Chamber, my name is Xu Dongni. I'm the counsel for defense, and this is my co-counsel, Zhong Yuxiang.
Thank you. And now I turn to counsel for the government.
Mr. President, Your Excellencies, my name is Dhruv Sharma, and I appear and represent the interests of the government of Southaros. I'm assisted by my co-counsel, Amritanshu Das.
Thank you. The team of the registry is represented today by Court Officer Wilfred Ndunga and Mrs. Iona Muraru and Ms. Teresa Lumbama from the Grotius Centre for International Studies. Finally, I'd like to introduce the bench. To my left is Mary Ann Power, to my right, Philip Ambach, and I'm Judge Howard Morrison who will be presiding over this hearing. The Chamber will now proceed consecutively with the 3 issues shaping the subject matter of today's hearing. Being mindful of the public nature of this hearing and the duty of the Chamber vis-à-vis the rights of the defence, I would ask the court usher to please read the count. Please, court usher, proceed with the counts brought against the suspect.
Thank you, Mr. President. On the 15th of March 2012, this pretrial chamber issued an arrest warrant for Theon Redbuck, a national of South Eros, finding that there were reasonable grounds to believe that he is criminally responsible under Article 25(3)(b) and Article 28 of the ICC statute for acts constituting crimes against humanity, mass killing of non-combatants, committed in the territory of North Eros under Article 7 of the statute. This arrest warrant was issued at the request of the ICC prosecutor and based on the facts set forth in the 25 January 2012 report of the UN High Commissioner for Human Rights entitled The Situation of Drone Strikes in North Eros. This case arises out of allegations of crimes against humanity committed in the territory of the Republic of North Eros, which is a state party to the ICC, having ratified the ICC statute in 2007. These crimes were allegedly committed by the aerial forces of the Republic of South Eros, a state that has not ratified the ICC statute under the authorization of the defendant, Theon Redbuck, who was at the time in question the head of the South Eros military regime. Both South Eros and North Eros are parties to the UN Charter, the 1949 Geneva Conventions, and the additional protocols thereto of 1977. North Eros referred the situation of drone strikes in North Eros from 1 August to 17 December 2011 to the ICC on 26 January 2012. After a preliminary examination, the ICC prosecutor decided on 1st February 2012 to initiate an investigation into the North Eros situation. Thank you.
Thank you, court usher. I will now give the floor to the defence to present its case and to discuss the three issues on the agenda for this hearing. First, whether the pretrial chamber can rely exclusively upon a report by the United Nations High Commissioner for Human Rights in finding a sufficient evidentiary basis for the issuance of an arrest warrant. Secondly, whether the pretrial chamber was correct in its legal conclusion that an official who orders a series of drone strikes to kill leaders of a terrorist group where widespread injury to civilians was a predictable result of such action can be criminally liable for crimes against humanity. And thirdly, whether the pretrial chamber was correct in interpreting Article 98 of the ICC statute to preclude the issuance of a cooperation request for arrest and surrender by a state party of the former head of the military regime of a state that is not a party to the ICC and has not waived his immunity. So I call upon Defence Counsel. Thank you.
Distinguished members of the Appeals Chamber, may it please the courts. My name is Xu Dongni. I'm the counsel for defense. It's a privilege for me to address the court three issues in this case. First, the report by UN High Commissioner for Human Rights does not constitute sufficient evidentiary basis for issuance of arrest warrants because it is of low probative value. And second, Mr. Redbuck shall not be criminally responsible for crimes against humanity because the drone strikes were not directed against the civilian population. And third, Mr. Redbuck enjoys immunity before the ICC. And with your permission, I will proceed on the first issue. Your Honors, we respectfully submit that the report by UN High Commissioner for Human Rights does not constitute sufficient evidentiary basis for the issuance of arrest warrants. According to Article 58 of the statute, at this stage, the threshold is reasonable grounds to believe. And it was held by the court that to issue an arrest warrant, the evidence must establish a trustworthy fact and must have a minimum of probative value in order to protect the fundamental right of liberty of the accused. However, the report in question, which is of extremely low probative value, cannot meet this standard. To this end, I have two reasons. First, the report in question lacks detailed information concerning the methodology, such as the way of conducting the interviews and the sources of news accounts. We've noticed that the Darfur report made by the UN High Commissioner, which was admitted in the Bashir case, is much more sufficient and detailed than our reports. In that report, the High Commissioner specifically noted that they had conducted 3 investigations, and even the original statement of those witnesses was contained in the footnotes. And compared with that report, our reports mentioned nothing about the methodology, and even the Darfur report was not used as a sole basis for the issuance of arrest warrants. Therefore, the report in question certainly cannot be exclusively relied on to issue an arrest warrant. And the second reason is that the report by UN High Commissioner is to review the human rights violation instead of the personal responsibility of Mr. Redbark. And the High Commissioner does not share the prosecutor's obligation to investigate both the incriminating evidence and the exonerating evidence equally. Thus, the High Commissioner may only focus on investigating the information unfavorable for Mr. Redbark. And in this case, the prosecution, who has the obligation to investigate the exonerating evidence, didn't conduct any criminal investigations. And we submit that this is unfair for the defense, because at this stage, we have no opportunity to investigate the credibility or the reliability of the content of these reports. Thus, we submit that the report by UN High Commissioner for Human Rights does not constitute sufficient evidentiary basis for the issuance of arrest warrants. Your Honors, if you do not have further questions, I will proceed on the second issue. Your Honors, we respectfully submit that Mr. Redbark should not be criminally responsible for the crimes against humanity because the drone strikes were not directed against the civilian population. It was held by the court in Bemba case that directed against refers to the primary object of the attack rather than incidental targets. That is to say, the attack cannot be directed against only a randomly selected group of individuals. And in this case, I have 3 reasons to illustrate that the drone strikes were not directed against civilian population. First, Mr. Redbark has made it very clear in his order that the drone strikes were aiming at hunting down Senator Clifton and the leaders of HO members. And nothing was mentioned about civilian people. So how could something didn't even appear in the order would be a primary object of an order? And second is that Mr. Redbark used the method, the location-oriented method. First, we have intelligence sources. We have got the information concerning the location of the military base built by HO members. And we have reason to believe that the people working in headquarters and trained in the training centers were HO members. And normally, civilian people do not have access to the military base. And yes?
Counsel, if I may interrupt you here very quickly. How can I know that these members of that group that you're making mention of are not civilians themselves?
Your Honors, we submit there is an armed conflict between South Rose and HO members. Because it was held by the court in Katanga case, in Lubanga case, that the armed conflict should be determined by the 2 prongs. The first is the intensity of the conflict, and second is the organization of the parties. And To the first one, we submit that the HOO members has conducted 3 attacks against Southros and caused more than 300 casualties, as well as the massive destruction of Southros railway system, and thus the intensity prong has satisfied. And also, HLO is a very well-organized group. It has more than 1,000 members and was led by Mr. Senator Clifton. Thus, and also they are capable of carrying out military operations. So the organization prong has satisfied. So we submit that there is armed conflict between Southros and HOO. Thus, the HOO is a legitimate target of the military operation launched by Mr. Redbar.
Yep.
One question, just very quickly. What makes you believe that this group is able to carry out military strikes? Because from the facts of the case, if I'm not mistaken, you will correct me if I'm wrong, we are looking at sabotage acts, but not necessarily military engagement of military forces. If you could elucidate me on this.
Honors, as it was stated in the fact that HO members has built military has built armed caches and training centers, and they also received non-lethal aid from Northros. They are financially supported, so we submit that they are capable of launching military actions. Yes. Mr. Redbark used a very precise guided weapon, the drone, to attack those military bases. And that's what Mr. Redbark had done to minimize the collateral damages. And Mr. Redbark did not intend to cause the civilian casualties. And my third reason for that is from the whole picture of the drone strikes. Before the drone strikes, Mr. Redbark ordered the manhunting for Senator Clifton in the caves of Project Mountain. And when Senator Clifton fled to the north side of Project Mountain, we asked the cooperation for the Northros, but we failed because Northros refused, and we do not diplomatic relationship with them. And then Mr. Redbark ordered the drones, and during the drones, we used a very precise guided weapon to minimize the collateral damages. And after Senator Clifton was dead, we ended the drone strikes immediately. So from the whole picture of this military action, we can reasonably infer that Mr. Redbark is aiming at hunting down Senator Clifton, and those unfortunate civilian casualty is collateral damage from our military action.
Thank you.
Yeah. Yes, Your Honor, if you do not have another question, we go to the third issue.
Yes, please.
Your Honors, we respectfully submit that Mr. Redbark enjoys immunity before the ICC. It was held by ICJ in a arrest warrant case that a former foreign minister might be tried for the acts committed during his period of office in a private capacity. And that is to say, a former state official cannot be tried for the acts committed in official capacity. And in this case, Mr. Redbark, as the effective head of state, authorized the drone strikes through the normal military channel and observed the government policies. Thus, his action is under the color of law. So this, yes, Your Honor.
What would you say to the proposition that he may have been a de facto head of state,
Yes,
but was
he's
not a de jure head of state?
Yes, Your Honors. Actually, the functional immunity contains 2 types, as you mentioned, the de facto or de jure. And the key point for functional immunity is the immunity attached to the nature of the tax, not the nature of the people, not the status of the people. So we submit that Mr. Redbark enjoys the functional immunity. Your Honors, we further submit that the functional immunity of Mr. Redbark cannot be removed before the ICC. Your Honors, when talking about the immunity issue, we should first bear in mind the differences between ICC and the ICTY and ICTR, because the latter two ad hoc tribunals were created by UN. And because of the universal membership of UN and because of the Security Council solution are binding to all the UN members, so the provision of ICTY and ICTR are binding to almost all the states in the world. However, ICC is a treaty-based court which the Rome Statute is not binding for a third state. And in this case, Southros is not a party to the ICC. So the ICC cannot invoke Article 27 to remove the immunity of Mr. Redbark.
Counsel, one quick question on this one. I think that we all know about some jurisprudence of another international court about this. And this other international court, again, if I'm not mistaken, has ruled that international criminal tribunals may exercise jurisdiction. That would not necessarily make the distinction between those, as you said, that are UN Security Council based, and others that might be treaty based, or others that might be treaty based with the consent of the General Assembly, in order to take another African example that did prosecute former head of state for crimes that have been committed during his office. If you could just elucidate me on this. Thank you.
Your Honors, we submit that we cannot deprive the immunity merely because this court is of international nature. Because if one state cannot deprive the immunity of another state, then how could 2 states or 10 states to act together to build an international court to deprive the immunity of another state? If there is no immunity before any international court, then would it be possible that, for example, the Nauru, the Andorra, they act together and create an international court where the immunity of United States President will be stripped? Yes.
One quick question as a follow-up. If I throw the term jus cogens at you, which should be law that is binding on everybody anywhere, how would you deal with that in terms of your contention that immunity would have to be sort of a rule that needs to be respected just as well? Thank you.
Honors, we submit that the criminal responsibility and the immunity are 2 different issues, because the responsibility belongs to the substantive law and the immunity belongs to the procedural law. And they will not conflict at the first place. And also, we cannot use the substantive issue to determine the procedural issue, because at this stage, if we assume that Mr. Redbark committed the crimes, then we stripped his immunity. That is a violation of the presumption of innocence. And if we remove the immunity based on a prior determination of whether the person is committed a crime, that is illogical. Yes.
What would you say to the proposition that if a person who held immunity in one state voluntarily left that state to seek refuge in another state, that by doing so he or she constructively waived their immunity from the state that they have left?
Your Honors, we submit that the immunity should be waived by Southros, the state that Mr. Redbark belongs to, not by the person itself, because we are discussing now is the functional immunity, and that means the immunity is attached to the acts, not the status of the person himself.
Thank you.
Your Honors, To be concluded, we submit that Mr. Redberg enjoys functional immunity before ICC. So the pro-trial chamber was correct in interpreting the Article 98 to preclude the issuance of cooperation request for arrest warrants.
Thank you.
Thank you.
Thank you. Now turn to the prosecution to present its submissions on the same three issues under discussion.
Your Honors, my name is Ayana Yakubovic. I will be pleading for the prosecution. Sitting next to me is my co-counsel, Ms. Sharon Oviram. The counsel for the defense wishes to draw this court into an ongoing controversy surrounding the issue of terrorism. However, the facts emerging from the materials examined by both the Office of the Prosecutor and the pretrial chamber are clear and simple. They reveal that Mr. Theon Redberg have violated international criminal law and the provisions of the Rome Statute. The drafters of the Rome Statute had presented us with their vision of certain courses of conduct that cannot and will not be tolerated at the 21st century. Allowing Mr. Redberg to evade justice today would leave the Rome Statute a dead letter, and it will not stop Southwest leadership from committing the same crimes. Your Honors, even if the HLO members are terrorists, such definition is immaterial to the question before the court today. Accordingly, the prosecution submits that nothing in the statute can prevent this court from issuing a cooperation request for an acting, let alone a former head of state. The prosecution further submits that Mr. Redberg's actions meet each and every requirement of both the crime against humanity of extermination and murder, whether he had predicted the widespread injury to the civilian population or intended that outcome. And the abundance of evidence included in the High Commissioner report forms far more than a sufficient basis for the issuance of an arrest warrant. Therefore, the prosecution urges the appeals chamber to give effect to the provisions of the statute. Nothing more, nothing less. My first submission will be regarding the material question of the crime. The prosecution submits that Mr. Redberg meet each and every requirement for both crimes against humanity of extermination and murder. He is liable according to Article 25(3)b of the statute. As there is no armed conflict in our situation, according to the Tadic case, as was applied in the Lubanga trial, Mr. Redberg had arbitrarily deprived the lives of almost 700 civilians. All the three conditions in the Tadic case are not met. As only 3 attacks were committed by the HLO members, the intensity is insufficient. As in their attacks, the HLO members used a common saw and acid. It's not enough for the organization feature to be established. And as the acts were merely sporadic, the duration is inconsistent with an armed conflict as well. Your Honors, by issuing a written order authorizing Southern military to conduct an average of 2 strikes a week over 6 months, Mr. Redberg had acted in a manner that fulfills the physical, contextual, and mental requirements of both crimes. According to Article 71A1 of the Elements of Crimes, if Mr. Redberg had caused death to more than one person, he fulfilled by that the actus reus of the crime against humanity of murder. Further, it is well accepted that there is no minimum threshold of victims required to fulfill the actus reus of the crime against humanity of extermination. After almost 700 civilians died, the pretrial chamber was correct in concluding Mr. Redberg had committed mass killing of non-combatants. The report further reveals that Mr. Redberg fulfilled the contextual requirements of both the crime against humanity of murder and extermination. Mr. Redberg had actually ordered a widespread and systematic attack directed against the civilian population. The attack was widespread, as more than 50 attacks were committed, and in the Katanga case, 10 attacks were sufficient to conclude that the widespread attack was apparent. The large number of victims also supports this claim. But the attack was also systematic, as the same use of the drone strikes indicate the non-accidental repetition of the attacks. Therefore, it was systematic. The attacks were further directed against the civilian population. First, the HLO members were civilians, as no armed conflict can be concluded in our case. The attacks that the HLO members had committed in the state of Cyprus were indeed unlawful under domestic law, but they were not such that would amount to hostilities, because they were not acts which by their very nature are intended to harm the equipment or personnel of an armed force. Even if some of the HLO members did take direct part in the hostilities at some point, if they flee to Northers, they cease to participate.
Counsel, very quickly. I deduce from the facts that the attacks that were committed by this group were aimed at a government-owned or government-owned facilities. Henceforth, one could say that the aim was at least the government. Would that not suffice for, say, a non-international armed conflict, that there be sort of an armed attack? Thank you.
Yes, Your Honor. First, the attacks were against 3 civilian trains, and the HLO member found it appropriate to announce to the public not to use these trains. Therefore, it was not their aim to harm the personnel of Cyprus. But as I stated, even if some of the HLO members did take direct part in the hostility at some point, at the time of the strikes, they ceased to participate. And even regardless of the classification of the HLOs as civilians or not, the attacks were still directed against a civilian population, the other civilians in the attacks. As ruled in the Courtroom I case and reaffirmed in Bemba confirmation of charges, the means and methods of the attack, the number and the status of the victims, and the lack of any resistance by them indicate that the attacks were directed against the civilian population. As the use of drones is usually very precise, yet somehow, in our case, 658 civilians were killed, civilians who made no resistance to the isolation during the entire 6 months. Can we truly see this conduct as respecting the vital principle of distinction? It seems not. Further, Mr. Redbark had concluded that all the Northern civilians are supporters of the HLO member, therefore can be attacked. But as ruled in Ruto confirmation of charges, when one classifies civilians as attackers for merely supporting, substantial grounds can be concluded that the attacks were directed against the civilian population. Mr. Redbark also acted with the mental element required under Article 30 of the crimes. Mr.
Counsel, very quickly, before you get to the mental element, or maybe you will be able to package this in your mental element. You mentioned the principle of distinction. I follow you there. But if I read directed against the civilian population, that sounds to me as if we're looking at a dolus directus first degree, i.e. I want to attack the civilian population. Now, the principle of distinction doesn't necessarily bring me there. The principle of distinction simply says I take it for granted that some civilians might be hit, or maybe it's some too many. But that doesn't bring us where the dolus directus of first degree would arguably point us when we're looking at the crime against humanity. If you could just elucidate me on this, thank you.
Yes, Your Honor. In order to define what a civilian population is, I used the principles of an armed conflict as allowed in Article 21(1)b of the statute, and as has been done in Bemba confirmation of charges. But it's only to understand whether the attackers were civilians. As I mentioned, the means and methods indicate that the attacks were directed against them. If we'll take an extreme situation, when one says that he direct arms only against Sander Clifton, yet thousands of civilians are dying, then the attack is directed against a civilian population.
Would you argue that the sheer numbers of civilian deaths make it unconscionable in itself and without more to be acceptable to to encompass it within the phrase collateral damage. In other words, that it simply goes beyond anything which a natural lawyer could tolerate.
Your Honor, can you rephrase your question, please?
Yes. Would you say that the sheer number of deaths, without more, without considering any other issue, just the sheer number of the civilian deaths, would make it unconscionable for any court to allow that to be encompassed within the phrase collateral damage?
Yes, Your Honor. As I mentioned before, not only the numbers of the victims, the use of drones, which could have been used precisely, but in our case did not, indicate that the attack was directed against the civilian population. It's not the specific use of drones, but how it was used. Mr. Redbach received reports on the civilian casualties, beginning with the initial sortie, yet made no attempt to halt them. If I may proceed to the mental elements, Mr. Redbach had acted both with duelist directives of the first degree or of the second degree. As I mentioned before, even if an armed conflict is consistent in our case, the HLO members did not take direct part in the hostilities at the time of the strikes. Therefore, Mr. Redbach had directed the attacks against them with duelist directives of the first degree. But his concrete intent can also be inferred, as was done in Bemba confirmation of charges, because he aimed weapons into an unarmed population, the Northern civilians. Even if he did not act with duelist directives of the first degree, he acted with the duelist directives of the second degree, as he could foresee that at the ordinary course of events, hundreds of civilians would die. As to my second submission, the abundance of evidence included in the High Commissioner's report forms far more than a sufficient basis for the issuance of an arrest warrant. My colleague wishes this court to overthrow the pretrial chamber decision regarding the evidence presented there. But I wish to recall the appeals chamber decision from only the 5th of March regarding Nataganda interim release. There, the pretrial chamber stated that it will only interfere in the case of a clear error. The chamber further revealed that the mere disagreement with the conclusion that the pretrial chamber drew from the available facts or the weight it accorded to a particular factors is not enough to establish a clear error. And similar interpretations were made in Bemba and Mabur-Shimano cases. Your Honors, at any rate, all the evidence in the report forms the reasonable ground basis. The hospital and morgue records indicate that almost 700 civilians died, and news accounts further corroborate that Mr. Redbach was the one who ordered the strikes and made no attempt to halt them, though receiving reports on the casualties.
If I could interrupt you there for one moment. Is it your submission that news reports are sufficient evidence to issue a warrant of arrest?
Your Honor, it's not my... news accounts are not enough at their own, but at this report there are various sources: news accounts, eyewitnesses interviews, morgue records, and hospital records. At any rate, news accounts in the Mabur-Shimano case, for example, were accepted as a source with probative value. But one possible inference from these facts is that Mr. Redbach had committed crimes against humanity, according to Article 7. This interpretation of reasonable grounds was made by Judge Usaka in a dissenting opinion of her in the al-Bashir case. Her opinion was later approved by the appeals chamber, and similar interpretations for that ground were made in Bemba, Gabago, Lubanga, and Katanga arrest warrant proceedings. As to my final submission, the prosecution submits that nothing in the statute, in Article 98 or elsewhere, can prevent this court from seeking cooperation of a...
Excuse me, counsel. I apologize that I have to bring you back to your previous point, but what would you make out of the fact that we don't know who these witnesses are? You're saying that we have a number of different sources, I grant you that, but I have no means to prove whether anything that I'm being provided by this report is accurate or not. So we're sort of in the area of unprovable hearsay evidence. If you could just give me a little bit more meat to the bone. Thank you.
Yes, Your Honor. The inherent reliability of the sources is but one part of the probative value of the evidence. As stated by Karim Khan, almost any aspect of the form, content, or origin of the information can be indicium of reliability.
Excuse me, the authority that you just cited, could you help me there?
He's a doctor, and in fact, the defense counsel for Bemba. So it's unique that the defense counsel actually states what I've just stated. As the report was made by the UN High Commissioner for Human Rights, previously relied upon, for example, by the Special Court for Sierra Leone, the report is sufficient for this low evidentiary threshold, in which only a prima facie threshold of reliability is required. The necessity of Mr. Redberg's arrest can also be inferred from the report, according to Articles 58(1)(a) and (b) of the statute. His prior connections as a head of state can help him evade trial, and the potential for lengthy imprisonment supports this claim, as was recognized in Hussein, Bemba, and Katanga arrest warrant proceeding. But as I was stating for my final submission, nothing in the statute can prevent this court from seeking cooperation from Westeros. As Mr. Redberg is not entitled to any types of the immunities listed in Article 98, I will focus on functional state immunity. Mr. Redberg had committed international crimes and facing accusation in an international court, therefore not entitled to immunity. Article 27 of the statute specifically rejects the notion that immunity shall be granted to heads of state. It would be absurd to deny such immunity under Article 27, yet grant it under Article 98. As stated by the pretrial chamber in al-Bashir case, granting immunity to heads of state would also severely disable international criminal justice and this court work in particular. This stands against all the preambular objectives of the Rome Statute, a statute ratified by Westeros. If we wish to put an end to impunity and to deal with the most serious crimes in concern of the international community, granting immunity to heads of state who most commonly hold in their hands the destructive powers to cause such crimes would be absurd. Granting such immunity would also be in contradiction to the long-established principle throughout international courts and tribunals that immunity shall not be granted to heads of state under their proceedings. This principle, customary principle, traces back to the International Military Tribunal and the International Military Tribunal for the Far East, which statutes both states that the position of defendant shall not be considered as freeing them from responsibility. The ICTY, ICTL, and the Special Court for Sierra Leone all took similar approaches. This court had actually summarized the subject by stating that the principle in international law is that immunity of either former or sitting heads of state cannot be invoked to oppose a prosecution by an international court. Under the ICC proceedings as an international court, there is further no concern that sovereign equality or the work of prime representative of state will be harmed. As recognized by the pretrial chamber in paragraph 36 of its decision concerning the incompliance of Malawi to arrest and surrender Mr. al-Bashir, the ICC does not constitute an organ of any state, and its mandate derives from the international community. As previously recognized by Professor Cassese, international courts are totally independent of state and subject to strict rules of impartiality. Therefore, the justification for such immunity are irrelevant, and it's a customary principle that immunity shall not be granted under this court to heads of state, as recognized by the Rome Statute in its provisions and preambular objectives. Mr. Redberg is not entitled to immunity today. In conclusion, Your Honors, the prosecution submits that Mr. Redberg is to be held criminally liable for acts amounting to crimes against humanity. Accordingly, that a warrant for his arrest should be issued on the perfectly sufficient basis of the UN High Commissioner report, and that nothing in the statute can prevent this court from seeking cooperation in giving effect to such warrant. Allowing Mr. Redberg to evade justice today would leave the Rome Statute a dead letter. Enabling Westeros to refuse the cooperation request would make this court an instrument of impunity, not the platform of its end. Therefore, the prosecution urges the appeals chamber to give effect to the provisions of the statute. Nothing more, nothing less. Thank you.
Thank you. Having listened to the defence and the prosecutor, I now invite counsel for the government of Southeros to present to the chamber its arguments on the same issues. Thank you.
Good afternoon, President Morrison, Judge Pavel, and Judge Ambacht. My name is Dhruv Sharma, and I appear before this honorable court representing the interests of the government of Southeros and Westeros in this case against General Theon Redbark. At the very outset, this government objects to the issuance of an arrest warrant against the former head of state of Southeros and the consequent exercise of untenable jurisdiction over him. The general, in addition to being the former head of state of the Republic of Southeros, is a citizen of a non-member nation over which this court is not binding. It is to this extent that I will be addressing this court for the next 20 minutes, establishing primarily why the pretrial chamber 6 was correct in precluding a cooperation request to the Kingdom of Westeros, which has a clear conflicting international law obligation. I will then consolidate and further the case of the governments by making two more arguments. Firstly, that the report published by the Office of the High Commissioner for Human Rights is insufficient to be relied upon solely for the issuance of an arrest warrant. And secondly, that the issuance of an arrest warrant was erroneous in the present case as no crime within the jurisdiction of the court has been committed. Your Excellencies, and may it please the court. Coming to the first submission, that the pretrial chamber 6 was correct in precluding a cooperation request in the present situation. The Kingdom of Westeros has a clear conflicting international law obligation of respecting the head of state immunity, or immunity ratione materi, of General Redbark. This principle of immunity ratione materi has a long-standing pedigree in international law, recognized by the International Court of Justice in paragraph 58 of the arrest warrants judgment, and also by the Al-Atsani judgment of the European Court of Human Rights. Excellencies, the principle behind such policy is to respect the sovereign equality of states. Moreover, Excellencies, there exists no exception to the principle of immunity ratione materi, even for the commission or the allegations of the commission of international crimes, as can be seen from a variety or a plethora of state practice. For instance, the dropping of charges against Rose Kabuye by France and Spain during the ICTR trials, the dropping of charges against the former Uzbekistan Interior Minister alleged to have committed crimes against humanity by Germany and France, and similarly the dropping of charges against Donald Rumsfeld, the Secretary of Defense of the United States of America.
Counsel, let me quickly interrupt you here. I'm grateful that you're mentioning very much in the beginning the ICJ judgment, paragraph 58. I believe that either in the preceding or in the paragraphs thereafter, there's some other notions of exceptions to immunities, and I would be very interested to hear to what extent there might be possibilities for international courts to have such an exception granted. And once you're at it, if you could tie in the question of jus cogens in here, because I would think that international court crimes are jus cogens, and how you reconcile this with your submission of the absolute value of immunities. Thank you.
Very pertinent observation, Your Excellencies. In fact, in paragraph 61.4 of the arrest warrants judgment, the court held that immunity may be abrogated in front of certain international criminal tribunals, such as this court itself. However, Your Excellencies, this requirement will be fulfilled only on the fulfillment of two tests, as laid down by Judge Shahabuddin in the case of prosecutor versus Kristic in front of the International Criminal Tribunal for former Yugoslavia, and reaffirmed after the arrest warrant's judgment by renowned scholar Deepu Akande. These two requirements are, Excellencies. Firstly, for the abrogation.
Excuse me, one quick question. Shahabuddin and Kristic, was that the majority or was that his dissent?
It was indeed the dissenting opinion, Excellency. Excellency, in the present case, the two requirements are, firstly, the abrogation of an immunity should be done within the provisions of the statute. In this case, that would be Article 27(1). The second requirement is the official whose immunity is being abrogated must be a citizen of a member state. It is this requirement which is not met in the present situation, Excellencies. Excellencies, it has been observed by this court in the cooperation request made to the Democratic Republic of Congo this very year that this court cannot be made binding on non-state parties and therefore cannot create rights or obligation on part of non-state parties. This was in fact a recognition of Article 34 of the Vienna Convention on the Law of Treaties, which states the same. Excellencies, moving on to the point of jus cogens norms. Excellencies, it has been observed in the majority opinion of the Al-Adsani judgment that even for jus cogens norms, immunity may not be abrogated. In fact, Your Excellencies, this was reiterated by the International Court of Justice in the case of Germany versus Italy, in which the court stated that the principle of jus cogens is a substantive principle, that is of substantive crimes. However, the principle of immunity is a procedural principle, and therefore these are two very different principles, never conflicting with each other. Therefore, Excellencies, immunities shall indeed be pleaded, even for jus cogens norms. Any development that may be argued that international crimes have formed an exception for immunity is only a treaty development, Your Excellencies, as was noted by the prosecutor here. The provisions of the tribunal at Nuremberg, at Far East, International Criminal Tribunal for Yugoslavia, Rwanda, SCSL, all have provisions within their statute and have been made applicable only to member states. The only distinction here is the case of al-Bashir, which was, Your Excellencies, referred to the court by a Security Council resolution. The resolution specifically stated that all members to the United Nations must cooperate in the arrest of al-Bashir, and that is why all states are obligated to arrest al-Bashir, and not because his immunity is abrogated under Article 27(2). Having made its submissions regarding the issue of immunities, I would now, if there are no further questions, obviously, Your Excellencies, I would now move on to my further arguments. The first alternative argument being that the report published by the Office of the High Commissioner for Human Rights is insufficient to be relied upon solely for the issuance of an arrest warrant. I sense a question, Excellency? Moving on, Your Excellencies, I will be making two arguments before this court. Firstly, unfortunately, this court has followed a wrong threshold in its previous judgments when relying or establishing reasonable grounds to believe. And secondly, even if the threshold is made applicable, which was previously followed by the court, even that threshold is not met by the present report. Coming to my first argument, Excellency. Article 58 states that an issuance of an arrest warrant shall be made against a person if there are reasonable grounds to believe that the person has committed a crime within the jurisdiction of the court. This court, in its previous judgments, such as issuance of arrest warrant against Lubanga, Abu Garda, and Kashyap, has relied upon the reasonable suspicion standard of the European Court of Human Rights. The reasonable suspicion standard, as clarified in the case of Fox, Campbell, and Hartley, states that an arrest warrant may be issued against a person if to an objective observer there is reasonable suspicion that the accused may have committed a crime within the jurisdiction of the court. Excellencies, belief denotes a higher level of acceptability than mere suspicion. In fact, this opinion is shared by Judge Pickis in paragraph 3 and 4 during the interim release of Lubanga Diallo, and reaffirmed by the court in the case of issuance of arrest warrant against Germain Katanga in which the court stated that mere suspicion simpliciter is not sufficient for the issuance of arrest warrant. In fact, Excellencies, it is this difference between has in the present case in Article 58 and may during the clarification of reasonable suspicion standard that member states to the Rome Statute were specific in rejecting the reasonable suspicion standard, as is clear from the rejection of Article 28 of the International Law Commission's draft on the Rome Statute, which stated the probable cause standard to be if there is a probable cause that the accused may have committed a crime within the jurisdiction of the court. Excellencies, the intention of the member states is clear that they believe a higher threshold or a higher standard is to be made applicable for curtailing the liberty of a person before the International Criminal Court. In the present case, Your Excellencies, if you may refer to paragraph 2 and 3 of the pre-trial Chamber 6's judgment, it is clearly stated that they haven't even found the 5 chapeau elements of crimes against humanity being fulfilled. And they have stated that the attacks were widespread, that there were a high number of casualties, but have not specified that there was a nexus between the act of the accused and the final commission of the crimes.
Counsel, a quick question on your first submission. I read from the pretrial chamber's decision that it found reasonable grounds to believe. Do I have to understand your first submission that that in itself is erroneous? Is that your submission?
Yes, Your Excellencies. However, what we are trying to state is to come to a finding of reasonable grounds to believe when there is a doubt in all the issuance of arrest warrants before this court, such as Lubanga, Kashyap, Abu Garda, the court has specifically delineated paragraphs to how there are reasonable grounds to believe that the attacks may be widespread. The attacks may be directed against civilian population. There might be nexus of the act of the accused with the final perpetration of the attacks. In the present case, Your Excellencies, this is lacking. In fact, Your Excellencies, the value to be attached to this report is so low that even the reasonable suspicion standard is not met before this court. Excellencies, the reasonable suspicion standard is not met in the present case, going by the case of the bar table motions presented in the case of German Katanga, in which the court stated that the probative value of an evidence may be analyzed on a variety of factors, such as the source and purpose of the evidence. The evaluation of evidence is done by such evidence presented before the court. In the present case, the source of the report is one report, source of the evidence, Your Excellencies, is one report published by the Office of the High Commissioner for Human Rights, which has a universal mandate of protecting and promoting human rights conditions in member states and not of setting individual accountability, much less individual criminal responsibility. In fact, this apprehension is shared by a renowned scholar, M. Sheriff Bassioni, who states that United Nations reports lack any standard of individual accountability and are made under a political mandate of pressurizing governments to adhere to their human rights violations. It is therefore submitted, Your Excellencies, that the source and purpose of reflected from the report, as can be seen from the appendix first page, that the purpose of the report is to report on the situation existent in Northeros and not to set any individual accountability, much less criminal responsibility. Moving on to the evaluation of evidence done by the report. Excellencies, the report relies on 3 kinds of evidence: newspaper accounts, hospital and morgue records, and anonymous witness interviews. Judge Ozaki, in her separate and partial dissenting opinion, stated in the Bemba admission into evidence that newspaper reports have to be given very low, if any, probative value, because they are hearsay evidence and are publicly opinionated. Even in that case, Your Excellencies, when newspaper reports were admitted before the court, firstly, they were corroborated by other pieces of direct evidence, and secondly, the name of the publisher of such report or the author of such report, the date on which that report was published, the partisan nature of that media company was also submitted to this court. In the present case, Your Excellencies, it is not a newspaper report that this court has to rely on, but a report which in itself relies on a newspaper report. Moreover, Excellencies, coming to the hospital and morgue records, Firstly, Your Excellencies, whenever hospital and morgue records have been submitted to the court, the details of the hospitals, the number of victims at each hospital, the names of the victims, the status of the victims has been submitted to the court as an annexure. In the present case, Your Excellencies, neither the names nor the date on which such evidence was taken has been submitted to the court. In footnote number 109 in the arrest warrant issued against Gaddafi, this court took into consideration hospital and morgue records only after the names of the hospitals and the persons who were dead was produced before the court. Yes, Your Excellency.
Counsel, one quick question here. We are in pre-trial. The standard, as you've said it yourself, is inferior to what we would need at later stages of the proceedings. We know the source of that still unknown sort of evidence is the High Commissioner for Human Rights. Would that not make the argument viable that one said, well, you know whom to ask in order to test this evidence, and if this evidence is unreliable, to bring at a later stage that argument before the judges?
I will be making two responses to that question, Your Excellencies. Firstly, the reports published by human rights, by the UN High Commissioner have been severely criticized, even by the publishers of the report in the past, such as the Goldstone report, which was published and then criticized in an op-ed by former prosecutor Goldstone himself. Secondly, Your Excellencies, during the issuance of an arrest warrant against General Ruto, this court specifically ordered the prosecutor to produce before it all the witness statements that it had relied upon for the issuance of the arrest warrant, and declined to issue an arrest warrant even at this stage in the absence of any witness statements being annexed to the prosecutorial application, which only summarized all the witness statements. In fact, Your Excellencies, the mandate of the prosecutor is in fact to bring individual criminal responsibility. The UN reports summarize the witness statements, anonymous witness statements, that is, Your Excellencies, with no mandate of finding, incriminating and exonerating evidence, and therefore no value can be attached to such a report. It is therefore, much obliged, Your Excellency, it is therefore argued before this court that this report does not even raise reasonable suspicion in the present case. In fact, Your Excellencies, Judge Sylvia Fernandez has opined, even during the reasonable basis to proceed stage, that one indirect evidence must always be corroborated so that the true account of facts can be arrived at. It is therefore argued, Your Excellencies, in our second submission that the issuance of an arrest warrant must be cancelled against General Redbach, taking into consideration the low probative value and the consequent no reasonable suspicion arising out of such report. If there are no further questions, I will now move on to my third submission. Excellencies, the prosecutor here has argued that there existed no armed conflict between the HLO and the South Ross government. Excellencies, we will be establishing the armed conflict, but before that, if I may direct your attention to the question before this appeals chamber. The question is simple, Your Excellencies, whether the attacks were directed against civilian population. The question is not of intention. The question is not whether the attacks were widespread or systematic, but whether they were directed against civilian population. The threshold of coming to directed against civilian population is different in case of an armed conflict, and it is higher, as has been opined in the ICJ judgment, paragraph 25 of the Nuclear Weapons Advisory case, and also in paragraph 91 of the Kunaraj judgment. Excellencies, in the present case, the dual requirement of armed conflict, intensity and organization, are clearly met. Considering that there are 800 people who have died, considering there is a high level of troop mobilization evident from the 20,000 troops sent to hunt for sand art lifting, goes on to show that the intensity requirement, as stated under paragraph 175 of the trial chamber judgment of Boskowski, has been met in the present case. Similarly, the minimalistic requirement of organization stated under the Limarge case and the Boskowski judgment are met, considering that the HLO had headquarters, armed caches, military training centers, followed a hierarchical structure, spoke in one voice, that is of Sandor Clifton, goes on to fulfill this requirement of organization. In the present case, rights asserted in paragraph 195 of the Boskowski judgment. Excellencies, the principle of distinction and proportionality, if met in the present case, would exonerate any intention of the attacks being directed against civilian population. To come to a finding of directed against civilian population, it must be established that the civilians were the primary objective of the attack. In the present case, Your Excellencies, the principle of distinction has been met in consonance with Article 48 and 51(1)(b) of the Additional Protocol 1. The attacks were temporally limited to the fact that, considering the fact that they ended once Sandor Clifton was found dead. In fact, Your Excellencies, the last attack only states that 24 others were killed. If I might have 1 minute of your court's time.
I don't think that's within my mandate, but thank you very much for your submissions.
It was an honor pleading before this court, Excellencies.
It's plain that important points have been raised in the statements made by each of the parties and participants. And now each party will be given in the same order the possibility to reply to the points made by opposing parties. But I would like to remind you that in respect of the time allocated for this part of the exercise, no team will be given more than 10 minutes for their rebuttal. So I would call upon Defence Counsel, please, to proceed.
Your Honours, my name is Zhong Yuxiang. I will complete this round of rebuttal. I will go first the immunity issue. The prosecutor mainly relies on 3 points to establish the conclusion that Ms. Redbach does not enjoy immunity before this court. First, Article 27, second, Basha case. Third, the development of international criminal justice. I will address them one by one. First, we submit Article 27 cannot apply to a non-state party. The reason is quite simple, that a treaty cannot bind is a third state which does not consent to the treaty. And then for the Basha case, I have the following 4 comments. First, Basha case was referred to the court by UN, and this case is not. So we submit the principle behind Malawi decision is the immunity of Mr. Basha has been deprived by UN referral. It's not the conclusion that in customary international law, the immunity cannot be invoked before the court. And I would like to address why International Criminal Court, the ICC, cannot strip the immunity of a non-state party. Actually, in Malawi case, this honorable court refers to the ICJ of the arrest warrant case, which in its famous obiter dictum stated that the immunity of either former or sitting state officials cannot be invoked before certain international criminal proceedings. Although ICJ listed the ICC as an example of those certain criminal proceedings, but by doing so, the ICJ explicitly referred to Article 27. Therefore, we submit that ICJ does not say explicitly for non-party the immunity cannot be invoked before this court. And the reason is ICC is different from ICTY and CTR. If a non-treaty-based court can have wider power than its state parties, that's to say, what a party cannot do, what a state cannot do, 10 states can do it collaterally, collectively. That seems, yes, Your Honor?
Counsel, but isn't that the purpose for Article 51 of the UN Charter?
Article 51 of the UN Charter.
Of the UN Charter, which establishes the right of self-defense, which means by an agreement of all, there's a certain moment in which one state can override the sovereignty of another.
Your Honor, we submit the collective self-defense is different from the collective exercise of jurisdiction, because if one state cannot strip the immunity of Ms. Redbach, why can they act collectively? The principle behind this is a state, when a state seek to prosecute someone unilaterally, there's no real difference between that scenario and the scenario that 10 states act together. And since in our case, Ms. Redbach is a national of Southwest, which is non-party to the ICC, which means the international nature of the court itself cannot deprive the immunity of Ms. Redbach. And the Basha case, the Malawi decision, simply has been overturned by a more recent decision of Pretrial Chamber 1, the Congo decision. In Congo decision, the Pretrial Chamber 1 did not rely on the customary international law, but the Security Council referral to deprive the immunity of Mr. Basha. So that comes back to my first argument. UN referral is important. Okay. And even if we admit that a distinction should be made between international court and national court, even if we admit international court can have wider power than national courts, we submit, in this case, the court should still be refrained from issuing a cooperation request, because it seems self-contradictory that if we draw distinction between international court and national court in terms of immunity, then we come to say, when it comes to cooperation request, we are dealing with the immunity vis-a-vis a state, the requested state. Therefore, it's different from the immunity before the court. Or to put it another way, the issuance of arrest warrant concerns the immunity before the court. The issuance of cooperation request concerns the immunity vis-a-vis a state, so they are in different levels. And finally, for the third argument of the prosecutor, the development of international criminal justice, we submit the development of international criminal law lies in the substantive field, and immunity issue is a procedural issue. This separation first can deal with the Youth Corgan's argument, and more importantly, I will address why the availability of immunity, a procedural issue, cannot depend on substantive issue. Two reasons. Because, first, if we do so, we are proceeding based on a presumption of guilt. At the stage where immunity was raised, we do not know whether Mr. Redbach is guilty or not. And if we deprive his immunity for the reason that you have committed international crimes and the proceeding has been instituted, then the whole proceedings are based on the presumption of guilt, which is, of course, unacceptable. And if immunity can be simply deprived by the claim of international crimes, then, as ICJ pointed out in the case of Germany versus Italy, any immunity could be deprived simply by skillful construction of your claim. And the second reason why we can't confuse procedural law and substantive law is if the determination of availability of immunity is relied on a prior determination of a substantive law, of the legality of the acts of the accused, it is totally inconsistent with the very purpose why we have immunity in the first place. The immunity rule is based on the concept of equality of state sovereignty. And equality of state sovereignty simply prevents a state from adjudicating on the legality of the act of another state. So if the availability of immunity depends on the prior determination of legality of the act, it's just illogical to the rationale behind it. And finally, we submit at this stage, there is no customary international law which lifted functional immunity for international crimes. And since immunity rule has been well established in traditional international law, we do not deny the development of international criminal justice, but simply at this stage, the state's practice is rather inconsistent. As can be demonstrated in Basha case, the issuance of cooperation request for Mr. Basha has been issued in 2009. Up until now, nearly 5 years has passed. No state has surrendered Basha. So therefore, we can see the inconsistency of state practice, especially when we consider the sharp disagreement of African Union Commission. And also, we can even see the inconsistency of practice from the jurisprudence of this honorable court. the Congo decision just released 1 month ago simply overturned the Malawi decision. And that completes my my rebuttal for the immunity issue. Okay?
One question. Could a person who seeks asylum in another country ever be regarded as adopting a parallel mantle of citizenship? Because by seeking asylum, they seek the same legal protections of citizenship that the other citizens of the country have.
Your Honours, we submit that the asylum request of Mr. Redbach cannot be equated as a waiver of immunity. Even if we admit the request for asylum is seeking protection as a citizenship, but it doesn't mean when it comes to immunity, and as we have mentioned by my co-counsel, since immunity of Redbach is rooted at the notion of state immunity, then only his state can waive his immunity. So even if Mr. Redbach, Westeros granted Mr. Redbach asylum, it doesn't mean Mr. Redbach waived his immunity because he has no authority to do that. Waiving immunity is within the power of a state, not a person. And for the immunity issue, if Your Honours do not have further questions, I will move. Okay, that's okay.
Thank you for your submissions. I turn to the prosecution now, please.
Your Honours, the prosecution wishes to address 4 points raised by my fellow counsels. As to the question of inconsistent with international obligations under Article 98.1. In his written memorials, the counsel for Southwest argued that Mr. Redbach, because he authorized attacks against the civilian population, is the victim of persecution, racial persecution, no less. Southwest submitted that Westeros was obliged to grant him asylum under the Refugee Convention as a matter of jus cogens, that the clause excluding persons who committed a crime against the peace, a war crime, or a crime against humanity can be ignored. I wish to congratulate my colleague for the eloquence of his words. But how can Mr. Redbach be a victim of persecution by Southwest, the same Southwest that appears here today with the state of Westeros in order to defend him? And where is the risk to Mr. Redbach's life? In the detention facilities of this court? This, Your Honours, is no more than a cynical smoke screen covering the simple truth. Westeros faces no inconsistent obligations and cannot invoke Article 98.1. Refugee protection is not an immunity and is not covered by this article. Mr. Redbach has no functional immunity before an international court. Relying on an obiter dictum of the ICJ arrest warrant case, a case concerning universal jurisdiction in a domestic court, cannot change clear established practice of the international community. It cannot undo the decision of this court in Malawi's in-compliance decision in the case of al-Bashir. Second, Your Honours, hearsay or not, the evidence contained in the report comes from various sources. It comes from morgue records, it comes from medical hospital records, it comes from news accounts and individual eyewitness interviews. Together, these sources generate sufficient probative value to meet at least the requirements of Article 58.1a. Deciding otherwise would compel the Office of the Prosecutor to exercise its privileges to the hilt, to apply for sealed arrest warrants again, and to sign confidentiality agreements. Third, Your Honours, there was no armed conflict between the state of Southwest and the HLO throughout 2011. If the situation did amount to an armed conflict at a certain point, that armed conflict was also created by the drone strikes conducted by the aerial forces of Southwest. Therefore, any claim of self-defense is peculiar. Southwest and Mr. Redbach, in particular, cannot initiate an armed attack, yet claim to be acting in self-defense. Fourth,
It was suggested by my fellow colleagues that General Redback did not know of the civilian casualties, yet acted in a manner that is proportionate to the direct military advantage. If General Redback did not know of the civilian casualties, then the drone strikes, which were disproportionate, are to be considered as directed against the civilian population, and General Redback can incur criminal liability under Article 28(1)(a) of the statute. Your Honors, General Redback has to choose. He either knew of the civilian casualties and therefore can incur criminal liability under Article 25(3)(b) of the statute, or he did not know of the civilian casualties and the drone strikes were disproportionate and therefore can incur criminal liability under Article 28(1)(a). Finally.
Counsel, one
Yes,
question here. If he didn't know about the civilian casualties, how would you then construe the first leg, which is the chapeau element of the crime against humanity, which is the directed against the civilian population? Thank you.
Your Honor, if General Redback did not know of the civilian casualties, he could not have calculated that excessive collateral damage in relation to the direct and concrete military advantage those drone strikes caused to the state of Saudaros. Therefore, since the drone strikes are disproportionate and taking into account the number of civilian casualties, the drone strikes were disproportionate and were directed against the civilian population of Saudaros. Finally, since both my colleagues insist on the existence of an armed conflict, the prosecution is willing to respond to their concerns. The prosecution, therefore, will not object to the amendment of the arrest warrant in conformity with Article 58(6) of the statute to include, alongside the crimes against humanity of murder and extermination, the war crimes enumerated in Article A2A1, Article A2B1, Article A2B4, or in the alternative, Article A2C1, Article A2E1. The arrest warrants in the cases of Bemba, Nagujulu was issued for both these types of crimes, and also German Katanga was also accused of both of these types of crimes. Your Honors, with this, the prosecution rests. Thank you.
Thank you. I now turn to counsel for the government.
With the permission of the court, I will now be rebutting the points raised by the prosecution counsel here. But before that, Excellencies, I would like to remind this court that this court will be judged, and indeed it will be judged by future generations. And it won't be judged based on the number of convictions that come out of this court. Not also on the issuance of arrest warrants made by this court or the acquittals made by this court, but by the fairness of the proceedings of this court.
I think you refer to the comments of His Excellency Judge Hunt.
And also Prosecutor Goldstone.
Yes.
Excellencies, I will now be rebutting the case of the prosecutor for the issue of crimes against humanity being committed. Excellencies, under Regulation 55 of the court, charges may be changed only by the leave of the court in front of the pretrial chamber. This is the appeals chamber, limited to 3 questions presented before it. The chamber, under Rule 158 of the Rules of Procedure and Evidence, can do only 3 things with these 3 questions: confirm the charges, reverse the charges, or amend the 3 questions. Nothing beyond that, Your Excellencies. And the argument that they will now charge the accused with war crimes against Article 67(1)(a) of the Rome Statute is illogical. Moreover, Excellencies, the prosecutor here has charged General Redback with the crime of extermination and murder. Excellencies, this charge or this count was never brought before the pretrial chamber in the first place, as is clear from the decision of the pretrial chamber 6, and therefore this is also against the rights of the accused under Article 61(1)(a). Going to the going to the requirement of an armed conflict, Excellencies, the prosecutor here seems to have confused the concept of direct participation in hostilities and continuous combatant functions. In the present case, Your Excellencies, even when the HLO members were not holding guns and attacking parties, they were in continuous combatant functions. And this has been held by several authors, and in fact is present in the guide to the by the International Committee of the Red Cross, which states that continuous combatant functions go through even when direct participation in hostilities is not being carried out. Therefore, Your Excellencies, the members of the HLO were continuous combatants and therefore a perfect target under an armed conflict. Does that answer the question?
Counsel, if you say that they were in continuous combat functions that makes them combatants, does that presuppose that we're talking about a non-international or an international armed conflict? Because I'm not quite sure whether the rules that you're citing are applicable in non-international armed conflict.
In fact, Your Excellencies, the rules are applicable in non-international armed conflicts and not in international armed conflicts. In international armed conflicts, if there are non-organized armed groups, they represent two states. And therefore, they will be soldiers and not civilians engaged in continuous combatant functions. In the present case, Your Excellencies, there is no international armed conflict, and only a non-international armed conflict. And the HLO is an organized armed group, and the members of it are engaged in continuous combatant functions. Excellencies, thereby the principle of distinction and proportionality are clearly met in the present case. The prosecutor here has failed to adduce evidence as to the first 49 drone strikes, and only the last strike may be taken into consideration before this court. In the last strike, Sandor Clifton was killed with 24 others, Your Excellencies. Others cannot amount to civilians, as was held by this court in the case of Dukumara in the confirmation stage, in which it stated that reports which use the words civilians, persons, others interchangeably cannot be solely relied upon to come to a finding that the persons who were targeted are, according to the legal definition of civilians, come within the ambit of civilians. In the present case, Your Excellencies, 24 others were killed and not civilians were killed. In fact, Your Excellencies, we argue, even if these were civilians, it has been argued by renowned scholars such as Ryan J. Vogel, Oscar Shatter, and Thompson, that high level of civilian casualties may be allowed and may be taken into consideration as a collateral damage if the resultant killing of the leader of the military superior is the cessation of hostilities in the case. In the present case, Your Excellencies, the killing of Sandor Clifton. I sense a question, Excellency.
Counsel, how would you ask us to interpret the fact that the report says that the individuals in question were attending a wedding at the time that they were targeted?
Excellencies, it has been argued by Ryan J. Vogel. In fact, it has also been argued by Philip Elston, the special rapporteur for the UN, that people engaged in continuous combat functions do not lose that status even when they go to bed at night. In the present case, Your Excellencies, if those 24 others were indeed engaged in continuous combatant functions, they do not lose their status merely by attending a wedding feast. Moving on, Your Excellencies, to the issue of evidence presented before this court. Excellencies, the prosecutor states that it is not bound to produce more evidence. Excellencies, this evidence relies on newspaper reports, which do not state and does not state which report or which account or which hospital record has been used to establish which finding within the report. When argued before this court, such reports must, under their methodology, clarify which evidence has been used to prove which allegation. Indeed, Your Excellencies, it is therefore that the report lacks any kind of probative value, and the reliance on anonymous witnesses cannot be accepted by this court unless the prosecutor attaches in its prosecutorial application, or in the absence of prosecutorial application in the present case to the UN report, the witness statements to be evaluated by the court itself and not by the UN High Commission. To the last submission, Your Excellencies, we again reiterate that the immunity ratione materia is not abrogated in front of the International Criminal Court because Republic of South Ross does not recognize the jurisdiction of the court, and in consonance with the judgment of the Democratic Republic of Congo, this court is not binding on non-state parties. The Republic of South Ross categorically asserts the immunity of General Redbach and states that the acts of General Redbach of authorizing drone strikes were pursuant to state policy to defend the territorial integrity of government of South Ross, and this court cannot adjudicate upon that matter. With this, Your Excellencies, the Council rests. It has been an honor, Excellency.
As we still have a moment, are there no bounds to the limits which would be acceptable even if an individual didn't lose competent status as to where they were at the time of a drone strike? My learned colleague has raised the issue of a wedding feast, but supposing that somebody with competent status suffered a minor injury and was in a hospital clearly marked with the symbol of the International Red Cross at the time that he or she was identified as being there, would you say it was acceptable to launch a strike in those circumstances?
Excellencies, that principle will be the principle of hors de combat, and perpetrators cannot attack individuals who have gone hors de combat, as the intent of the attack must be to put individual hors de combat, and once they have achieved that status, they may not be attacked anymore. Therefore, Your Excellencies, in the situation when a person is injured and in a hospital, thereby he may not be attacked by enemy troops. But in the present situation, the combatant status was not lost merely by joining a wedding feast, Your Excellency. Much obliged, Excellency.
Yes.
Sorry, I just have one quick follow-up question. You mentioned the fact that the warrant of arrest in your submission cannot at this stage be amended in response to the prosecutor's suggestion that they were willing to amend the warrant of arrest to add war crimes to the crimes for which the warrant had been issued. Could you revisit the question or your answer as to why this can't be amended at this point in the proceedings?
Excellency, the court, under Rules of Procedure and Evidence, Rule 158, read with Article 82 of the Rome Statute, can only confirm, reverse, or amend the questions put before the appeals chamber. The question of changing the warrant or changing the charges, I apologize, Your Excellency, can be made only in front of the pre-trial chamber under Regulation 55, which allows for recharacterization of charges, which was also raised in the case of Lubanga Dialogue during the pre-trial chamber hearings in that case. If Your Excellencies are satisfied with the answer.
I thank all participants and advocates, and the bench will now leave the courtroom to proceed with the deliberations. Of course, people can leave the courtroom, but I ask that everybody is back here present no later than 15:45 hours. Thank you. Court usher, please.
All rise.